Good evening. I think it's probably a mobile phones off, please, or on silent. I've always wanted to say that. In my previous life, I always wanted to be Harvey Goldsmith at the front of Live Aid saying, "Move back, everybody." But that doesn't quite apply tonight. Welcome, one and all, to this inaugural collaborative insight event between Ince solicitors and our chambers at 25 Bedford Row. First and foremost, might I thank everyone at Ince & Co for agreeing to partner with us tonight, and correspondingly for showing their wonderful facilities and their hospitality. Sparing blushes, might I have a call out for Emma Makepeace, Deputy Director of Clerking at 25 Bedford Row, and Colette Kelly and Sarah Stewart at Ince for their combined investment of time, patience, and support in making this happen after I first discussed the kernel of this idea with Emma a couple of months ago. And lastly, on behalf of everybody, might I thank all our panelists for agreeing to take part, and especially all of you in attendance for choosing to forego a lovely summer's evening in your gardens, or one in the array of nearby hostelries, or washing your hair, or otherwise finding something better to do than kindly to engage in our discussion about the terribly exciting Economic Crime, Transparency and Enforcement Act of 2022. In the context of economic crime, the ECT and EA, and it's a mouthful and equally uncomfortable and cumbersome, whether you give it its full title, I think, or abbreviation, and hence, therefore, I shall call it throughout the Act, is an important piece of legislation, we think, that has otherwise passed under the radar somewhat since it was heralded into law a couple of months ago. It has been largely overshadowed by recent events, of course, and the excitement of sanctions being imposed upon certain individuals and entities said to be associated with or having benefited from their links to the Kremlin directly or indirectly in the advent of the Russian invasion of the Ukraine, and also, of course, the long-standing consideration of a comprehensive economic crime bill and the threat of introducing into law, I say personally, God forbid, the corporate offence of failing to prevent economic crime, whatever that may be. Whereas tonight's topic might not otherwise set your pulses racing, the approach we intend to take is to briefly identify what the Act has in store and examine its breadth in the wider context of the challenges faced in addressing more general considerations of economic crime, particularly from the perspective of practitioners representing clients on the receiving end. Accordingly, all views expressed are our own, and notwithstanding, I'm told that some of this is going to be recorded and might be sent out for distribution. I'm going to work on the basis that Chatham House rules apply. This is a deliberately informal environment with the intention of generating, I hope, a relaxed, lively, yet informative discussion. The precise scale of what is loosely termed economic crime in the UK is largely unknown. And it ranges annually from, depending who you're reading or who you're speaking to, from anything in the tens of thousands of pounds to the hundreds of billions of pounds. The spotlight on the scale of economic crime in recent years, I think, has been focused upon three key events, particularly in the last 2 years, that individually and collectively inform the extent of illicit wealth that flows through the global economy in general and the UK, especially this wonderful city of ours in particular. And these three events are, and in chronological order, the September 2020 leak of the FinCEN files, FinCEN, of course, is the United States Financial Crime Enforcement Network, and the FinCEN files refer to the more than 2,500 documents that international banks sent to the US authorities between 2000 and 2017. The leak was the dumping of data to BuzzFeed News that then shared the content to investigative journalists around the world. In essence, the files show the extent of suspicions of international money laundering harbored by the international banking community to be in the range of $2 trillion. The significance of the FinCEN leak above the earlier leaks of the Paradise Papers in 2017 and the Panama Papers in 2016, deliberate alliteration, is that they are not just documents from one or two companies or referable to one or two individuals, but as they come from a whole host of international banks. The second event is the October 2021 leak of the Pandora Papers, back to alliteration. The cache refers to the 11.9 million files from companies hired by wealthy clients to create offshore structures and trusts in tax havens such as Panama, Dubai, Monaco, Switzerland, and the Caymans. The files exposed how the most powerful people in the world, including more than 300 politicians from 90 countries, use secret offshore companies to hide their wealth. And the third event, of course, is in February of this year, the Russian invasion of Ukraine that resulted in global sanctions imposed on thousands of corporate entities and persons linked directly or indirectly to the Kremlin. The precursor of this year's Economic Crime Transparency and Enforcement Act was the original draft bill dating back to 2018 to tackle, and I quote, dirty money and mafia wealth, as it became to be known, laundered via UK-held real estate and other assets. However laudable, the legislation remained on the back burner as UK government otherwise obsessed, you may remember, with Brexit and then something called COVID. Everything, however, changed on the 24th of February this year when Russia invaded Ukraine. On 28 February, the government hurriedly announced its draft bill for this particular act, and on the same day, the Department for Business, Energy and Industrial Strategy published its white paper on reform of Companies House. After some refinements, the former gained royal assent on the 15th of March, and the latter will underpin a further economic crime bill in respect of which the government has announced it is committed. The overriding objective of the Act is to crack down on dirty money and corrupt elites by creating a register of beneficial owners of UK real estate owned by overseas entities with the objective of improving transparency and toughening existing legislation concerning UWOs, unexplained wealth orders, and sanctions. In tandem, the aim of the white paper on reform of Companies House is to better trace and monitor the ownership and funding of UK registered companies by an expanded disclosure and intervention scheme. The Act, quite unusually, applies across the entire United Kingdom and comprises, as I'm sure most of you, if not all of you, will know, three parts that are the creation of a register of overseas entities, Part 1 of the Act, Sections 1 to 44, amendments to the Unexplained Wealth Orders regime, Part 2 of the Act, Sections 45 to 53, and amendments to the existing legislation on UK sanctions, Part 3 of the Act, Sections 54 to 66. And we can expect the reforms of Companies House to be introduced into law shortly. And that is why we are dealing tonight with all four aspects. As you will all have gathered, I am here to moderate tonight's discussion, and it is my pleasure to do so. For those of you who do not know me, I'm Simon Pentel. I'm Queen's Counsel at 25 Bedford Row, from where, for the past 25 years, I have led for defendants in all aspects of serious fraud, which is not actually that impressive. It just makes me realise that I'm not as young as I'd like to think I am. And on the basis that self-praise is no recommendation, I'll say no more about myself, but will happily focus on our distinguished panel, to whom I now turn because they're going to get concisely into the detail of all four aspects. And I'm going to take them in order of the discussion. Part 1 of the Act, the Register of Overseas Entities, Matthew Biles, who sits immediately to my right. Matthew is the head of the Ince Private Client and Tax Team in London. He specialises in private client matters with particular focus on UK inheritance tax, capital gains tax, income tax, and complex international elements of UK tax advice. Matthew's experience includes advising both UK nationals on their personal tax and succession affairs and international individuals on matters including residence, domicile, and remittance issues. He has particular expertise advising high and ultra-high net worth international clients, like to meet some of those please, on wealth structuring, asset protection, and investment structures. Part 2 of the Act, Unexplained Wealth Orders, will be provided by Duncan Jones. Duncan is sitting in between Nikki and Colette, and Duncan is part of our specialist fraud team of counsel at 25 Bedford Row. He specialises in white-collar defence advice, advocacy and investigations. He works at an exceptionally high level of complex financial and business crime matters involving issues of considerable public importance and global investigations. Duncan is frequently instructed to represent professionals, high-profile and high-net-worth individuals, not very high net worth, in relation to sensitive matters. He has acted for individuals at trial and pre-charge in 4 major SFO investigations: Unioil, G4S, ENRC, and Alstom. Between 2020 and 2022, Duncan successfully defended Ziad Akel in the SFO Unioil investigation and subsequent prosecution that culminated with a landmark decision of the Criminal Court of Appeal to quash the conviction and refuse the FSO's application for a retrial. And if that wasn't enough, and I can personally vouch for it, he is an outstanding junior. Part 3 of the Act, Sanctions, Colette Kelly. Colette, as you will all know, is a partner here at Ince and an experienced criminal regulatory solicitor of note. She boasts 20 years of expertise, and her practice focuses on the defence of serious and complex allegations of white-collar fraud, proceeds of crime, restraint orders, and asset forfeiture. She also acts for third parties in confiscation proceedings, often involving investigations into complex trusts in offshore entities. Atop all of this, Colette also has considerable experience in reputation management, including advising at pre-charge stage and making successful written representations to the CPS, FCA, and other law enforcement agencies whereby her clients have avoided criminal prosecution. The government white paper on reforms to Companies House will be delivered by Nicola Howard, Queen's Counsel. Nikki is a highly respected silk and an established member of our specialist fraud team at 25 Bedford Row. She is predominantly instructed in large-scale complex fraud cases, bribery, money laundering, substantial confiscation, and corporate offending. She advises in highly contentious and sensitive cases regarding privilege, self-reporting, SRA investigations, and financial indiscretion. She is highly sought after to advise companies, office holders, and high net worth, not very high net worth individuals in a broad range of financial and regulatory matters. In her spare time, Nikki sits at the country's preeminent forecourt in Southwark as recorder of the South Eastern Circuit and has done since 2016. Without further ado, and thank you for your attention, if we can turn now please to Matthew, who is going to give us some insight into part 1 of the Act, the Register of Overseas Entities. Matt, if we can deal with it like this, the Act applies across the UK, and its purpose, per the explanatory notes, is to deliver transparency about who ultimately owns and controls overseas entities that own land in the UK. Can I ask, how will it do that? And in a nutshell, how will the register operate?
Yes, no problem. Thank you, Simon. As you can tell, I'm on a handheld, so anyone at the back, if they can't hear me, please let me know. So ostensibly, this part of the Act, Part 1, brings in this requirement to try and register what we call registrable beneficial owners, so RBOs. I suspect all of us in our professional lives have probably come across UWOs, ultimate beneficial owners, and this is a twist on that concept. The way in which the new rules work and the reporting procedure is that the overseas entities will be required to make a declaration to Companies House if they bought what they term a qualifying interest. I do apologise, this is slightly heavy on acronyms the next minute or two, in the UK since the Act came into force, which was 15 March 2022. Now, or indeed they've held a QI, qualifying interest in property, in England and Wales since 1 January 1999, in Scotland 8 December 2014. Sorry, this sounds like the COVID regulations, I suddenly realised. And in Northern Ireland since the Act came into force. So a qualifying interest is essentially a freehold interest in a property or a leasehold interest, which is over 7 years. So essentially what that does, it knocks out all of the kind of short-term leases, but thereafter, by and large, catches pretty much anything. Now, overseas entities, it's a new term, but essentially it's rather vaguely defined as legal entities governed by non-UK law, including the Channel Islands. So in particular, it doesn't catch trust because they don't have a legal personality, but it will pretty much catch, your standard company, so to speak. Without delving into tax law too deeply, what I think that will really mean is in the UK, it will be offshore companies that probably hold commercial property. There were some tax changes in April 2017, which made it very unattractive to hold residential UK properties in offshore companies. So by and large, I think it will be kind of the commercial property holding companies that will be hit. I mean, I think the truth is this has been coming down the tracks for a long time, as Simon touched upon. There's been a whole raft of these kind of intergovernmental information exchange agreements in recent times. The US started it with FATCA, essentially as being one of the dominant economies in the world. It started forcing people to disclose information to them. A lot of other jurisdictions jumped on that bandwagon with the Common Reporting Standard, again, acronym heavy, Common Reporting Standard, the CRS. And then the UK has the Persons of Significant Interest Register, which is very much like this, but reporting on UK solely focused companies. There's also the Trust Registration Service, which has just recently come in. And just as a note for your diaries, September 2022 is the deadline for that. And that catches a lot of trusts, so we suspect there'll be a lot of slightly concerned trustees desperately meeting that September deadline. And then the most recent is this, the Register of Overseas Entities. As Simon touched on, I think invariably the salacious headlines that came from the Pandora paper leaks, the Panama paper leaks have really taken us down that path, even though it was originally drafted in 2018, I believe, by Theresa May's government, and it took a war to get it introduced, but putting that aside. And then, so to continue on with the process itself, so the overseas entity, bear in mind, some of them will be run by families, but a lot of them will be run by professional administrators. They're required to take all reasonable steps, and remember that phrase, reasonable steps, to identify and disclose a registrable beneficial owner, this RBO entity or person. So an RBO, what is it, you'll wonder? So it's an entity or person that owns 25% of the shares in a company or 25% of the voting rights in the overseas entity, or has the right to remove or appoint the majority of the board of directors, or has the right to exert significant influence or control, or even if that right doesn't exist, they do it anyway. And I really think that last half of that third criteria could cause some significant issues because it's so vaguely defined. But I'll touch on that a little bit later. And then in relation to the actual process itself, so Companies House, the Register of Companies in the UK will be the gatekeeper of all this information. The report will have to be made. As probably all know, it's a free of charge service, publicly accessible. So depending on their process times, whatever is filed will be open to the public at short notice, and of course open to journalists as well, which of course is no bad thing. And then obviously the information will need to be updated annually as well. So there's a rolling requirement to continue to keep these companies informed and keep the details accurate.
Actually, if I could just ask you for a moment, forgive the interruption, but the Act, as I understand it, provides that any overseas entity wishing to own UK land would need to identify their beneficial owners and register them, in essence. And the Act, or the regime, is to apply retrospectively to overseas entities that became registered proprietors of land pursuant to an application made to the land registry on or after the 1st of January 1999 for England and Wales, and a few years later in Scotland. And what I was wondering and seek your assistance with, firstly, do you think there's any loophole that's been left for in respect of property that's acquired before the 1st of January 1999 in England and Wales and before the 8th of December in 2014 in Scotland?
In short, yes. I mean, I suppose suggesting a loophole was left deliberately perhaps is a step too far, but I think there are certainly holes in the legislation completely. Why they picked that deadline, that 1999 cutoff, is not clear. Maybe they have concerns about overwhelming Companies House, so they tried to limit it to a 22-year period. Perhaps there are donors of certain parties who have knows who 1998 is a big year. But
I'm glad you said that.
Yeah, exactly.
Everyone else was thinking it. But,
yeah, quite. But no, I mean, there's no clarity. I do honestly suspect it's probably just to simply put an end point and limit, because we all know government departments in our personal and professional lives who are just, they've had years of austerity, then they've had COVID. You can literally name almost every department is struggling with this workload. So I think this is probably to draw a line in the sand.
Okay, but on the same topic, of course, Part 1 of the Act has not gone live, and the register hasn't gone live yet. And there's a 6-month transitional period from the date upon which it does go live. Do you think that creates a risk of asset flight? And should the Act have introduced transitional provisions to prevent real estate from being sold before the register comes into force?
I'm slightly wary about this becoming a slightly critical of the government that introduced this bill.
So
I shall try and answer that. But I think if we take a kind reading, perhaps the thinking was that they didn't want to perhaps limit the free market, and therefore a transitional rule coming in might have had to be quite draconian and blanket, i.e., any property owned by such an overseas entity couldn't sell it until they were registered, in which case, that could have frozen all the transactions for 6 months. So perhaps it's a free market argument. If we were being less kind, we could say that the government has had a lot on its plate and in its wine glass in recent months, and therefore the legislation perhaps has been rushed and big areas have been missed. The third option, I suppose, is perhaps they feel that the sanctions do some of what they brought in. So essentially, as you all probably know, a lot of Russian-connected figures are now sanctioned individuals. And that has massive ramifications for the UK professional advisors. Our compliance teams are, having to review every Russian relationship. And therefore, perhaps they think that, well, if they were to dispose of any assets or take them out of the UK, they would need to interact with, estate agents, brokers, solicitors, accountants, all of whom have compliance departments, and therefore the likelihood is the majority would hamper those Russian transactions. I think from memory, Helena Bonham Carter's cousin was down as a legal owner of a mansion in the one Wentworth estate, which it has since come to light was held on behalf of a Russian oligarch. And that sale went on the market before that individual was sanctioned, but it very quickly went off the market.
Yeah.
And I suspect that's probably because as the kind of the sanctions were coming down the line, perhaps the estate agents or the lawyers started asking real tough questions about the UBO, and they either didn't get the answers they wanted, or perhaps more terrifyingly, they did get the answer, and therefore they pulled out of it, which of course torpedoed that transaction.
You've told us that the plan is that Companies House, when it does go live, will operate the register, and this will become a recurring theme. Is there sufficient allocation of resources to make it fit for purpose?
No one from Companies House is here, right? Again, to be fair, Companies House is one of the more efficient government bodies I interact with in my day job. But I do fear that this will just be an onslaught of registrations, and the knock-on effects of that are hard to predict.
I can help you with some of the funding proposals for the Companies House stuff when we get there.
Yeah. I'll handily pass over this question.
Well,
But I think, yeah, it will cause issues. I mean, the biggest one is the land registry saying that until you have a Companies House identifying number, that they won't process transactions. And so even if all these applications are done right first time, which is a big if you don't have this ID number, you can't sell your property, you can't remortgage it. So will we actually have a kind of a grinding to halt as, I don't know, turnaround times, 3 months, 6 months, 9 months? It could have a real knock-on effect with the kind of conveyancing that some of these law-abiding citizens want to undertake.
well, bearing in mind you can't get a passport, good luck getting your overseas entity registered in good time. But speaking of that, what are the penalties for non-compliance? And do you think they go far enough, given the thinking that lies behind the construction of the register?
Well, so the offence is the failure to register or knowingly or recklessly making a false statement in relation to the OE register. And so the tools that the government's hands are restrictions on the property preventing a sale or indeed a mortgage, criminal sanctions for the overseas entity, and bear in mind, and their officers. And bear in mind, a lot of these overseas entities will likely be run by professional administrators as well. And so those sanctions can include fines, daily fines of up to £2,500 and up to 5 years in prison. As to their effectiveness, I think in all truth, the fines are probably relatively paltry, given the value that these ultra high net worth people likely own. I think the custodial sentences will have much more bite, especially for these administrators, because it really will focus minds. I mean, obviously, we all know a raft of incredibly professionally run, offshore administrators, but there are also kind of horror stories as well. I think some of those individuals need to look closely at their compliance and make sure that they're compliant. I do think the offence, though, there could be somewhat of a perfect storm, perhaps even just for inadvertent kind of breaches. So you may recall the obligation is to make all reasonable steps in relation to your declaration. And then the third limb of the beneficial owner is if someone can exert significant influence or control, whether by right or in reality. But how do you breach the miss to see that in reality? If it's via phone call or gentle nudge in the pub to the individual concerned. And then the authorities have a discretion in deciding that if a declaration has been made recklessly, that falls foul, and they could then be subject to these fines and potentially prison sentences. So those three parts, I do worry, is probably the greatest kind of uncertainty in the offence, and there is it, probably rubbing its hands together.
And just to wrap up, because obviously we've got a lot of ground to cover, the Act, so we're quite clear, applies only to the beneficial owner and not the land itself. And does this, therefore, do you think, allow for an overseas entity or a UK entity to hold interests in UK land on trust for overseas beneficiaries without the requirement for registration? And if so, is this somewhat self-defeating?
Yes, in short, it's another big hole in the Sanctions, really. It's another big hole in the legislation. So essentially that's a nominee arrangement or a bare trust, some of the terms you may have come across. And what is the way the current need to register is drafted is it focuses on the RBO, the overseas entity, so essentially the company. So you could literally have a company holding as nominee for an individual, but because that individual doesn't trigger any of the requirements, the 25% shares, the significant influence, etc., even though they're the ultimate beneficial owner of the property, it's simply the bare trustee that we need to report, and no information about the beneficial owner, ultimate beneficial owner, will go to the authorities. And similarly, if you have a trust which owns a company, which owns a property, the way it's currently drafted is simply the what we call the underlying company in the middle needs to report. They don't look beyond that level to the trust structure at the top to find out who the trustees are, who the beneficiaries are.
Well, that's good, because we can now write a book on how to avoid the
Avoid
register of
not
overseas
obeying.
entities. Thank you very much. I'm going to move on, if I may, to the next part of the Act, Part 2, Unexplained Wealth Orders, and Duncan, created, of course, by the Criminal Finance Act of 2017 as an investigative tool. Remind us, if you would, what are UWOs and how do they work?
I'm just going to stand up.
Please do.
Key change. So, unexplained wealth orders are nothing new, as I'm sure many of you know. They've been available actually since January 2018. And they are effectively an investigatory order, which is placed on a respondent whose assets appear to be disproportionate to their income. And it's an order essentially that they explain the origins of their wealth. An unexplained wealth order isn't a freestanding power to confiscate assets, but it can give law enforcement the opportunity to confiscate criminal assets without ever having to prove that the property was obtained through unlawful activity. They were nicknamed, you may remember, McMafia orders, and they were targeted originally at people with links to serious crime or involved in serious crime, where exceptionally criminal prosecutions were unavailable, or those who were foreign politically exposed persons and those connected to them. And foreign means those from outside the European Economic Area. The orders allow specific enforcement agencies, the NCA, HMRC, the FCA, the SFO and the CPS, to apply to the High Court for an order that requires the subject of the order to explain their interest in particular property and how they obtained it, provided that the property is valued at least at £50,000. But there have been a lot of problems with these orders, and the government, with this new act in 2022, have chosen to introduce reforms which are designed to make obtaining those orders easier, but also, importantly, to reduce the risk to enforcement agencies of applying for them, because they have been faced with large cost orders, or at least one large cost order in relation to a failed application.
If I could just pick up on that, Duncan. And if I can ask for further assistance, it's my understanding is to date, only 9 UWOs have been issued with an estimated value of about £140 million. None, of course, and we'll come on to it, have been issued since 2019 for reasons with which we are only too familiar. And the only agency to employ the regime has been the NCA. What are the key elements of the Act that seek to address the lack of success of the current regime? And how do you think this will pan out?
Well, the Act changes the unexplained wealth order regime in 4 ways. The first is to broaden the category of people or categories of people against whom they can be obtained to include the responsible officers of an entity that owns property, which might include a director, a manager or partner of a partnership, both in and outside the UK. And that's to get around or to address the issue of dealing with complicated corporate entities that may hold interests in property. That's the first major change. And the second is to change the test applicable, or to add an alternative test applicable to the decision as to whether to grant an order. And that is to add the option of applying on the basis that there are reasonable grounds for suspecting that the property has been obtained through unlawful conduct. And that's different from the situation before, because before the changes, the grounds were that there were reasonable grounds for suspecting that the person's known sources of lawfully obtained income are not sufficient to enable them to obtain the relevant property relating to the order. And that sounds a little bit complicated, but in the high-profile failure in the Baker case, the problem that the NCA had was that Mr. Baker was named on lots of documentation. He was the solicitor involved in the administration of companies, effectively. And although he was the person with an interest in the property, the value of his interest was very low, if not nil. And so the income requirement was not met in relation to Mr. Baker, because it couldn't be suggested that his income was not sufficient to fund his interest, because his interest wasn't really worth anything. The ultimate beneficial owner of those companies and those properties was someone completely different. Now, instead of that route, the NCA, who really are the only people applying for these orders, can simply assert that there are reasonable grounds for suspecting that the property was obtained through unlawful conduct. It takes it away from the individual.
But in that case, and it's very well known, of course, the Aliyev Baker case, where the beneficial owners of the property were the mother and son. Aliyev's, 3 houses worth £80 million. But of course, both at first instance, in particular, and then at the Court of Appeal, NCA was absolutely savaged, particularly at first instance, by Christine Lang, for its poor investigation, its failure to appreciate that the wealth in question had been explained, so much for unexplained, and an over-reliance by the NCA on an assumption based upon the use of complex corporate structures of itself. Does the Act in any way do anything to address these types of failings? And if not, should it? Was it a missed opportunity?
Basically, no, the Act can't do anything really about those sorts of structures. And clearly there is a misunderstanding, or perhaps too much emphasis put on the complexity of corporate structures as being evidence in itself for suspicion or reason for suspicion, but simply requiring the responsible officers of companies to provide evidence of how, or information about how they obtained their interest in the property doesn't particularly assist. They might have to identify who is instructing them, those sorts of issues. But if the people who are the ultimate beneficial owners of the property want to retain it and to preserve their interest in it, it's in their interest to cooperate with the investigation, which has been seen in nearly all of the unexplained wealth order cases that have come before the courts.
You mentioned about costs, and of course this was fundamental in the Aliyev Baker case, because of course the NCA, after first instance and appeal, was left with a cost bill of £1.5 million. And just to put it into context, for the NCA, that equates to 1/3 of its annual budget for its international anti-corruption unit. Do you think that the costs cap introduced by the Act for unsuccessful applications for a UWO redresses any failures or simply incentivizes poorly funded investigations?
The euphemism that the government used when they announced this particular change was that it would, quote, increase operational confidence in the use of unexplained wealth orders, which I think means that they can act with virtual impunity. But it's no coincidence that the Baker judgment, which resulted in £1.5 million worth of costs against the NCA.
They've got enough problems.
So that judgment came down in April 2020. There have been no unexplained wealth orders since then. There have been no unexplained wealth orders since the end of 2019, unless there have been any ex partes applications since May when these changes came into force. It's quite clear. I don't think it's the pandemic that's caused that hiatus. I would suggest it's because the NCA had their fingers badly burned by the mistakes that they had made. They weren't necessarily investigatory mistakes. They perhaps didn't understand the complexity of the situation that they were dealing with. Their opponents were incredibly well prepared to respond to the unexplained wealth order, and they were proactive in dealing with it. But clearly, increasing operational confidence means removing the risk to the NCA in dealing with these
Do you think
issues.
there's a danger? Do you think there's a danger that once you remove once you create a cost cap effectively for the NCA or any other prosecutorial authority, that we might see essentially more and more UWOs suddenly being dished out for whatever reason, badly founded in fact and law, just because there's really no downside?
Well, it's possible, but there is a qualification on the protection against costs for the enforcement agencies. And if they're found to act unreasonably, dishonestly, or improperly, then they are at risk of costs against them. But the problem with all of that is that it leaves those who are faced with unexplained wealth orders, particularly say a manager of a company who might have nothing to do with the ultimate beneficial owners, who would have to defend one of these orders, probably on the instructions of the ultimate beneficial owner. But the fact that Baker's costs were £1.5 million is just an example of the risk then to those that are slapped with an order, because the applications are normally made ex partes, and then you have to unravel them afterwards.
And although this is a question, proper leading question, because I know we all know what the answer is going to be, having set out this new regime for a brave new world, therefore, when it comes to UWOs, does the Act do anything to ameliorate concerns over fairness and proportionality for those that might receive one?
No.
Perfect, thank you very much. Perfect leading question. If we can move on, thank you very much, Duncan. Can we turn to part 3 of the Act, which is sanctions, Colette? A hot topic at present, for obvious reason. Can we start? Can you enlighten us, please? In general terms, what is a sanction? What are sanctions when we read about them in the newspaper?
Well, can everyone hear me? Well, I hope that everybody knows what a sanction is. We've heard a lot about it in the news. It's a hot topic, but it's not a new topic. And they are restrictions, political, trade, or economic restrictions against target countries, groups, or individuals. And they're put in place by an international body such as the UN, or the EU, or states such as the UK or the US. And they have a specific foreign policy objective or a national security objective. And we've heard a lot about financial sanctions, trade sanctions, aircraft, shipping sanctions. But for the purposes of today's discussion, we want to focus on financial sanctions and the role of OFSI, which deals with the implementation and enforcement of sanctions policies. But before we move on to the changes to sanctions, which the Act will bring into force tomorrow, I just wanted to touch briefly on the existing regime under the Sanctions and Anti-Money Laundering Act of 2018. And that was passed to allow the UK to impose economic and other sanctions and money laundering and terrorist financing regulations once it left the EU on the 31st of December of 2020. And so the purpose of the Sanctions and Money Laundering Act was to enable the UK to create its own sanctions framework, whereby it it can issue its own sanctions rather than adopting EU or UN models, and to make provisions for the detection, investigation and prevention of money laundering and terrorist financing, and to implement standards published by the Financial Action Task Force, FATFA, rather than adopting EU directives. And there are also provisions relating to the registers of beneficial owners of overseas entities. And as has been touched on already, the idea of bringing in regulations goes as far back as 2016, but unfortunately it's taken the invasion of Ukraine for things to be rushed through. 24th of February is the invasion, and then with lightning speed we have the Act which came into force on the 15th of March, and as I said, tomorrow the new regulations in relation to sanctions will come into effect.
Well, this is the only part of the Act that's actually live.
That's right.
And the criteria on the primary legislation of SAMLA is a single criterion for where it's simply that it's deemed appropriate by a minister to order a sanction against a designated person or entity for the UK to meet its international obligations or one of its stated purposes. What, if anything, does the Act do in respect to amending that?
Well, the Act has brought in new urgent designation procedures. So what this will mean is that there's going to be no requirement for the government to have reasonable grounds to suspect that a target meets the criteria for designation under the UK sanctions. So there is the ability to impose autonomous sanctions, and that's really very far-reaching, because if they don't have to determine that there are good reasons for the imposition and that it's a reasonable course of action, it gives carte blanche to the UK government to issue those sanctions. But more importantly, the changes that come into effect tomorrow relate to a new strict liability. So at the present time, the regulations are that there has to be knowledge, a reasonable suspicion that sanctions, financial sanctions, have been breached. But from tomorrow, the new regulations, or rather the new part of the Act which comes into force, relates to a strict liability, which is going to have, I think, quite far-reaching ramifications. So at present, Ofsted can only impose monetary penalties where a person breaches financial sanctions if it's satisfied on the balance of probabilities that a person, when I say a person, I mean a designated person, which is an individual or an entity, that they knew or had a reasonable cause to suspect that they were in breach. And to date, there have only been 6 financial penalties imposed by Ofsted. The lowest was £5,000, and the highest was just over £20 million imposed against Standard Bank. So the new strict liability basis means that there's no requirement now for Ofsted to demonstrate that a person had knowledge or reasonable cause to suspect that they were in breach of a financial sanction to issue a monetary penalty. And I think it's important to remember that this only applies to consideration of a civil liability, and the imposition of a monetary penalty is not relevant to any assessment of whether a criminal offence has been committed under the sanctions regulations. But it is, however, still necessary for Ofsted to establish that there has been a breach of sanctions prohibitions to the civil standard. And what might be relevant to mitigation in terms of the level of actual and expected knowledge of financial sanctions held by an individual or a company, considering the type of work they do or their exposure to financial sanctions risk, I think there's no longer going to be any blameless breaches.
Yeah.
All breaches are to be considered serious.
I mean, as well, of course, the Act gives the Ofsted the power to publicly name companies,
Yes.
as I understand it, that have breached sanctions on the balance of probability, even though those companies have not been issued with a fine.
It's seen as an alternative to issuing a penalty, but the risk to the reputation of the company could be quite far-reaching. The guidance which has been issued, which comes into effect tomorrow, refers to situations in which there are valuable compliance lessons for industry. So they can publish a summary identifying who performed the breach, giving a summary of the facts of the case. So the breach type, the sanctions regime, the regulation broken, and whether there was voluntary disclosure. It is important to remember that obviously places, as do a lot of organisations, a lot of weight on any form of self-disclosure. And that's a really important factor for companies and individuals to take into account in determining whether they make that disclosure to OFSI.
It also creates a real onerous problem for those of us who are representing any entity or business that may or may not be directly or indirectly linked with a person or an entity that is sanctioned, particularly in the web of complex financial structures. And a wholly innocent entity might find itself caught up by being associated directly or indirectly with a sanctioned entity. From a practical point of view, how do you think any one of us can properly advise our clients who might be on the wrong end of this type of legislation when of itself discovering that it is going to take a lot of hard work?
It will take a lot of hard work, and I'm sure that we'd all be delighted to be instructed to deal with these sorts of cases. But whilst there is the new ability for OFSI to publish details of breaches, they do state that they will not publish where it's not in the public interest to do so.
How very kind.
Or where the impact of publishing will be considered to be disproportionate. So, lots of hard work for all of us in the room to be able to persuade OFSI that it's not in the public interest to publish details of breaches. But it's a very fine tightrope to be walked, I think.
Yeah, and just finally, if I may, and thank you so much for your contribution. Section 23 of SAMLA allows for a designated person to request that the minister vary or revoke the designation. The onus of proof, of course, is on the challenger. But set against the current or historic background, do you think that the likelihood of anyone at the wrong end of a sanction has much of a prayer to get a sanction lifted?
I think there's going to be a lot of prayers said, but not much coming at the end of it, because obviously you go through the process of the sanctions review request form, a decision is made on the request as soon as reasonably practicable, which we all know could be whenever. There is the ability to apply to the High Court for the decision to be set aside. The court must apply the principles applicable on the application for judicial review. And we all know how difficult it is to be successful in the High Court on a judicial review. So I think the prayers may be unanswered.
I mean, certain high-profile individuals, and Mr. Abramovich is one of them, have claimed that they may very well challenge the sanctions being imposed upon them. So just putting it in the context of what you said, I think if I've got this right, that it demonstrates how the difficulty in having a sanction lifted is that there are some who were sanctioned by the United Nations, and the backdrop is that those persons have remained blacklisted even though they're no longer with us. They're dead. I think which probably sets the real scope of the difficulty in meeting that burden.
I think so. I think I should have just said no to your question.
That'll teach you. Thank you very much indeed. Nikki Howard, Queen's Counsel, the Government White Paper on Reforms to Companies House. What are the principal objectives, Nikki?
Well, I'm very conscious of the fact that it's only me that stands between you and drinks in the sunshine on the balcony.
But that's not a defence.
So I might just ban Simon from asking too many questions so that I can do a quick whistle-stop tour through Companies House forms. But objectives, well, the white paper says this, and I quote, "The objectives will be achieved not just through legislative reform, but through a fundamental operational transformation of Companies House. In its systems, processes and capabilities, Companies House will change to reflect its new role in the economy and its responsibility to help achieve the government's priorities in national security, anti-corruption, tackling fraud and boosting enterprise." So they're not setting their sights too high. And in fact, the role of the registrar is set to fundamentally change instead of just being a remit really of registering company information, it will now include, and again I quote, promoting and maintaining the integrity of the Register of Companies and the UK's business environment. Now, we all know that that is a gargantuan change and also a gargantuan task. It's the biggest change since the creation of the role of registrar in 1844. And the idea is that they're going to deliver the government's ambition in terms of skills, culture, operating model, and services. Now, you touched earlier on funding. Well, the transformation, if you haven't noticed, is already underway. 20 million is being invested in 21 and 2022, with a further 63 million announced up to 2024-25, and that was the most recent spending review. But like all these things, proper resourcing will be at the centre of the efficacy of these transformations. Staffing, technology, and commitment will all be key, and that's all very fuzzy within the white paper. There's not a lot of detail as to actually how that's going to be implemented. Remembering, of course, that this is at white paper stage, there are many unknowns. There is guidance, sanctions, threatened and promised, but no real detail as yet as to how that will be enforced and how it will be implemented. So what sort of things are being considered as part of this transformation? Half a dozen main topics: identity verification, the registrar's powers, corporate directors sharing information, there's a lot of sharing information, and improved financial information. All of this is designed to make it more transparent, more reliable for those looking at it. So in terms of identity verification, anyone setting up, running, owning or controlling a company in the UK will need to verify their identity of the company's house. So that's all new and existing company directors, persons with significant control. Anybody else submitting filings will be required to verify their identity. If not verified within a certain set of time, that will be an offence, possible civil penalty. A company that's directed by an unverified director will also commit an offence, so watch out for that. And if an individual fails to verify, the register will be annotated so that anybody viewing it will know that that is an unverified director and therefore can make their own assessment as to integrity and therefore risk profile. So that's that. The greater powers of the registrar are pretty far-reaching. They include things like raising queries and also changing and removing information, which is a very big change. Companies House will be given the power to challenge suspicious information and to inform security agencies of potential wrongdoing. So a bit of sharing of information there before we even get onto the sharing information section. The registrar will be able to query information both pre and post registration to identify errors, accuracy, any anomalies that appear to be fraudulent or suspicious, or anything that may impact on the integrity of the register. They have no obligation to accept documents. If there's a query pre-registration, then the entity has 14 days to respond and provide evidence in relation to that. Failing to respond or address a query satisfactorily, and obviously there's no definition as to what satisfactorily means at the moment, the registrar will have a range of sanctions, which, although not finalised, are likely, it would appear, to include criminal sanctions. Guidance will be available, apparently, to understand that regime and how to avoid the problems. We will wait and see. The registrar will have the power to remove information from the register and also change the registered address more swiftly and in much wider circumstances than they're able to do at the moment. And also they can change the name to the company number if they're not satisfied that the company is legit, or they think that there's anything underhand going on, or if it's using a company name which is very similar to a brand or a bigger global company, which is obviously something that people come across quite a lot. Third thing, corporate directors. The future of corporate directors has been under discussion for a while, as I'm sure many of you know, and the reforms look to retain the ability to appoint corporate directors, but only in very specific circumstances. All of the directors of the corporate director are themselves natural persons. That's one of the conditions, and that those natural persons are prior to the corporate director appointment, all have to have been subject to the identity verification process, which I was speaking about just a moment ago. Corporate directorships will also be restricted to entities registered in the UK.
Sounds like, if I may say, from the perspective of an SME, that there's going to be a lot of red tape created here.
Well, it's interesting because there's always this tension between the two, because the one thing about coming out of the whole Brexit was that all the red tape was going to be cut and it was all going to be very much easier for everybody to do everything. This will increase red tape significantly, especially for SMEs. And in fact, if you speak to accountants about this, and if you go online, there's lots of articles about the amount of red tape that this will cause for small and medium enterprises. However, small and medium enterprises are also where much of that fraudulent type behaviour that Companies House transparency is meant to stop. It's not the really massive companies often that's the problem. It's in that area that they're trying to make more transparent, which is why there's now this enhanced data sharing, people having to record full names of shareholders, the registrar being able to share relevant information with law enforcement and other public and regulatory bodies, which is meant to sort of be the offset of that, really. I'm sure that the small medium enterprises will not agree with that,
I'm sure they will.
but that's the purpose of it. They can also share information with the Electoral Commission, anti-money laundering supervisors, when certain conditions are met. One of the things that for small and medium enterprises, which is the improved financial information side of it, because one of the things that they're trying to do is digitise all accounts, which sounds like it should be good. But obviously, one of the things for small and sort of micro companies is that it's meant to be simplifying everything. But it will be that all small companies are being required to file all of the constituent parts of the account.
So you can no longer fill it.
You can no longer fill it. So therefore, your profit and loss, your director's report, all now has to form part of the process, because one of the concerns was that being able to fill it, your accounts, means that it's not transparent, and also it means that when people are looking at it and wanting that information, it's not there to be found.
What about competitive protection from your business rivals? Your accounts are online. There they are.
Well, again, the accountants say that there's a split opinion on this. Some people say exactly that. Competitive advantage will be lost because people will be able to go and see what the profit was last year, etc. And the other side of that coin is that they say that people really don't have either the time or the inclination to be poking around looking at other people's accounts, and actually that's more of a myth than it is a reality.
Trust the accountants, yeah.
Well, that's the thing. So that's the position in relation to the accounts. There's going to be enhanced validation checks. They're trying to get everything over to digital filing. on one system. They've got this system called inline extensible business reporting language, and they want everything to go through that. One of the things that they are trying to do, which would be a good thing, is they're trying to explore the options of allowing companies to file financial information just once, using a centralised account submissions standard rather than separate filings for HMRC, Companies House, etc., etc. But that, of course, is still in its infancy. Companies House have said, we're ready to implement the biggest transformation to Companies House and to play our part in tackling economic crime and driving confidence in the UK economy.
Yeah, they're very bullish, aren't they?
They are very. I mean, they do seem very, well, they're very forthright. I think they're getting a lot of funding, and they're being asked to do a lot of different changes all pretty much at the same time. There will have to be a further economic crime bill.
Yep.
And the other aspects that they're looking at in relation to that are things like a power to seize crypto assets and bring them within the civil forfeiture powers, strengthened anti-money laundering powers to give businesses more confidence to share information. It's meant to be able to help company directors protect their personal information better, and reforms that bear down on limited partnerships as vehicles for facilitating international money laundering, that kind of thing, are all things to come. But that is obviously a very quick overview, but hopefully gives you an idea.
Any timeline with any of this, Nikki?
No.
Well, that's confidence building. And speaking of timelines, if I can ask anyone on the panel, we know that only part 3 is referable to sanctions actually in force, either some tomorrow and some already. Any timelines for parts 1 and 2 that anyone knows of?
No inside knowledge, but I think given recent events in the Conservative Party and the focus on their kind of legislative programme, presumably it will be up the top, and certainly part 1 I would have thought the next few months would come through, otherwise there'll be criticism, as you say, of asset flight, etc.
And for UWOs, Duncan?
The tweaks to UWOs came into force on the 15th of May. So in the last few weeks,
right,
they have just come into force.
So that's covered. Big issue is this. I'm going to ask the room, does anybody here firstly think that there's going to be sufficient resource and funding and organisation put behind this wonderful idea of Her Majesty's government? Well, that's a resounding confirmation of the confidence we all have in the new legislation to tackle economic crime.
Well, I think it's a problem because even if you look in the Times this week, there were the articles about the FCA and their lack of investigations, their lack of convictions, etc., all blamed, it would appear, on lack of resources and lack of funding. So, it's the same old thing. It's robbing Peter to pay Paul to.
It's a great idea, but if you
else.
don't have the people in place to carry it out, it's going to amount to a hill of beans. All right. Is there anybody on the floor that would like to ask a pertinent or not pertinent question? Gentleman with his hand up.
Colette, on sanctions, one thing that I've not really understood is franchise operations. So you're a company,
I'm just going to pause there because I don't really understand about franchise companies. So I'm just being honest. I'm here just to deal with the part 3 being implemented and the civil penalties. But the franchise operation in relation to gambling, are you concerned?
It's not just that, it's things like master services and that we found that it can get us their contracts.
It creates a real problem. Yeah. I mean, I'm sorry, but this is always with this. This is the law of unintended consequences, and I think a lot of this legislation, when it comes into force, is going to fall victim to that, and we can see it in a number of ways, particularly with sanctions, because they have been imposed across so many designated entities that the knock-on effect of all of this is way beyond, in my view, the original intention to bring to heel any government or anyone with links to the Kremlin. It's going to go far beyond that. And I think this is a classic example for me of the law of unintended consequences, and particularly when it comes to franchise models. And I understand what you're saying because, of course, it's link upon link upon link. And yes, it's very, very difficult. I think beware.
I'll just add one more point.
Please do.
So, and that is, where it is a group company of a UK company,
Yep.
UK company, that has the franchise agreement,
Yep.
where do they stand? An overseas group company.
Yeah, my clerk is sitting at the back there. If you want to have a word with him, I might, and we'll take it up afterwards. No, but it's actually the answer to the question. It's very complex, and I'm not ducking it. It is very complex because, quite simply, I don't think anybody, as I say, gave sufficient thought to the sort of question that you're raising. It all seemed very simple, and in response to, particularly to Ukraine,
This is what
let's get people sanctioned.
In 6 weeks. Nobody thinks about the wider consequences. People are so tunnel visioned about trying to deal with the problem that they think their legislation is trying to deal with, that they forget all of these unintended consequences, as you say, because it's simply not enough time to actually properly consider the detail of such a massive change.
But some of them aren't also, they're not financial or legal, it's bad PR. I mean, law firms have fallen foul of this. A number of them acted for the Russian banks that got sanctioned. One of them applied to come off, acting for them on the belief that they were being savaged on social media. And the judge said, no, even the Russians are allowed legal representation. But for that bank, to then have that client know that they applied to try and come off the record, to then have to go back on the record, and oh, by the way, my invoice is outstanding. It's
if you think that, and I'm moving away from black letter law, but if you think that as a result of all of this, that Russian and Belarusian tennis players have been prohibited from playing at this year's Wimbledon without any suggestion that Medvedev or anyone else has a link, direct or indirect, to the Kremlin or Putin, doesn't seem to matter. But decisions are being made, and that's why I talk about unintended consequences. So if you start with a franchise model, you end up with this being literally applied in spirit, if not in law, to decisions made by the All England Tennis Club about its tournament in a couple of weeks or next week. It's really quite frightening, I think. But this is the path we're on. That is why, from a personal perspective, I would say this as a lifetime defender of persons and entities, that you've got to be very careful when what is otherwise attractive and draconian, because it seemed like a good idea at the time, without considering where it all might lead, I think can be potentially very dangerous. And the problem we have is that none of the legislation, and I stand to be corrected, has any element of an amelioration clause in it upon which someone can hang an argument that simply it's unfair and disproportionate. Because from the lawmakers, none of it's unfair and none of it's disproportionate. And I think that's a fundamental problem.
Sorry, Andrew, just to really take up what you're saying. The new measures that obviously will have the power to impose penalties on a strict liability basis, I think means the next several months we will see more penalties being imposed. We will see more publications as well. And the obviously director has said that the policy driver behind these new changes is increased enforcement. And the reason why Part 3 has come into force is because by enforcing the regulations, you generate revenue. And that's frankly what it's about. It's more money for the Treasury's pot, which then can be dished out to other companies' house.
Companies' house, perhaps that's the plan.
Yeah, and I think it's going to be quite significant. And we're moving, I think, more towards a US model as well, which is about enforcement. The US may not have terrific money laundering regulations, but they sure know how to deal with enforcement. And so whilst I'm sorry I couldn't answer questions about franchises, I just think that it's important to say that I think moving forward, I think we will see in the next 3 to 6 months, certainly, quite a change in terms of Ofsted powers, because since 2016, 6 penalties is pretty poor. Really.
Yeah, poor return.
And it's a sex reputation.
Yes, absolutely.
Which is a very important element for any business.
So I would just mention the sort of other point, which is that notwithstanding the inconvenience, the embarrassment, the expense, the problems that these sanctions cause for businesses, there is a legitimate aim, which is to deal with the Russian issue and other issues around the world. And hopefully these things will be refined over time and improved as a result of the problems that will be identified by the sorts of people sitting in this room. But there is a legitimate aim ultimately to sanctions.
And I was never suggesting it wasn't, but of course the enabling legislation goes back to SAMLA in 2018 when we left the EU, because we needed our own legislation to allow for it. But the lowering of the threshold, I think, instinctively for me, is a problem. And no one's suggesting that the ultimate overriding or overarching ambition should not be met. But it's just got to be very careful, I think, in achieving that, what collateral damage might be caused en route. Anybody else like to pose? Yes, lady over here, please.
Another sanctions related.
Oh.
You're very popular. I think she's work really.
What do you see the chances of someone launching judicial review action against Ofsted? And if you've had any views over recent months, there are many reasons to do that.
Certainly, I think there's the possibility of launching the action, but whether it's going to be successful is debatable for the reasons we talked about earlier. You know, it's going to be very difficult, very costly, and if people are on a sanctions list, on that consolidated list, I think it may be difficult for them to get access to funds, maybe, to fund such a case. As always, we advise clients of the merits of their case, but I think it's going to be quite difficult, I think, to be successful in any JR or Section 38 application for sanctions list. I don't know what anyone else thinks.
Well, I mean, for me, I think you just hit the nail on the head. I think it's going to be a real uphill struggle to fundamentally challenge the imposition of a sanction when the threshold for imposition is so low. I mean, you're effectively going to have to say that that decision was made Wednesday wrong. That's not going to be easy.
I think it will need a very specific case that would allow it to be possible. You know, where the facts are so either unwieldy or so disproportionate that you could try it. But I think that in general terms, it
would have to be the right case.
It would have to be the right case.
Yeah. Anybody else? Don't be shy. We're only here once.
Yeah, they all don't have a drink.
Well, if that's it, I think it's time, at Nikki's insistence, that we wrap up. Once again, I'd like to thank you all for attending and for your very kind consideration and your attention. And I trust that you have left this insight both better informed and at least a little the wiser. Thank you all very much for coming.